Good morning, everyone. Thank you for joining us today. It's my pleasure to team up with Steve Turner and Nancy Cox, who are partners with the Bonadio Group on this presentation. I'm going to be covering hot topics and updates in employment and labor law, and Nancy and Steve are going to cover plan sponsor considerations as a result of changes due to the COVID-19 pandemic, as well as updates and strategies surrounding the Paycheck Protection Program and employee retention credits. Just to tell you a little bit about me, I'm a partner in Goldberg Segalla's Buffalo office. I'm a leader in our firm's employment and labor practice group. I'm also the chair of the higher education group at Goldberg Segalla. On a daily basis, I counsel clients on human resource and personnel issues involving compliance on leave of absence, harassment and discrimination, discipline, terminations, wage and hour issues. I also represent clients before administrative agencies and in court, should they find themselves in those situations. And I work with clients in all industries, including retail, healthcare, manufacturing, higher ed, and that covers the gamut. And with that, I'll get started. Just a quick disclaimer, nothing in the presentation should be construed as legal advice. We are trying to highlight, hot topics and issue spot for you. Certainly, if you have any specific questions regarding your situation, feel free to reach out to, myself or one of our attorneys for specific legal advice. We're going to start with COVID-related hot topics, since that seems to have been occupying much of our time for the last year. New York has been pretty busy. Recently, on March 12th, Governor Cuomo signed into law COVID vaccination leave. So this applies to all employers, both public and private. Each employee is allowed to take a sufficient period of time, is what the statute says, but it's up to 4 hours of paid leave per injection for COVID vaccines. And the law expires in December 30th, 2022. You must provide the paid leave as a benefit. You cannot charge an employee's leave bank, like PTO time or vacation. It is silent on what documentation you can ask an employee for after they get the vaccination. What we're recommending to clients, and everyone is giving out the vaccination cards, that you can certainly ask the employee for a copy of the vaccination card. If they have evidence of the appointment when they went, you can ask for that. It's also silent, unfortunately, on whether the employee has any duty to try to accommodate the shot around their shift. For example, if there are times available outside their shift, there's nothing that requires them to basically schedule it around their shift. There's an anti-retaliation provision, much like other employment laws, that an employee that does use the time for vaccination cannot be retaliated against. So we recommend that you update your policies and your handbook to include this new leave if you're located in New York. The EEOC recently issued guidelines on whether employers can mandate COVID vaccines. We were getting a lot of questions on this the last few months. I think we're going to get many more as vaccines become more widely available. In general, what we're counseling employees, the EEOC takes the position that you can mandate a vaccine if the business circumstances justify it, but you must take into consideration any request for a reasonable accommodation that might be applicable either under the New York Executive Law or the Americans with Disabilities Act. So, as a reminder, under the EEOC guidelines, under the ADA, there's limited circumstances where you can do medical examinations of employees and disability-related inquiries. There are limitations. So they are going to look at the vaccine as to whether it's job-related and consistent with business necessity. I think, there's stronger arguments, obviously, in the healthcare setting where employees are taking care of patients. There may even be stronger arguments in retail and public-facing positions, maybe less strong arguments in manufacturing where employees are not dealing with the public. Just considerations to, consider if you're considering mandating a vaccine. So under the reasonable accommodation analysis, of course, you'd engage in an interactive process, and If your employee has an individual medical condition for which a reasonable accommodation is necessary or the vaccine wouldn't be appropriate for them, you would be required to accept them from your mandatory policy on vaccination. The New York Travel Advisory Guidelines were recently amended. Interestingly enough, on March 10th, the governor issued all kinds of interim guidance regarding, going in and out of states that are non-border states and new quarantine rules. At the very next day, he said, well, effective April 1st, New York travelers into New York will no longer need to quarantine for domestic travel. So I do have the link to the interim guidance, which is technically in effect today and tomorrow, but then effective on Thursday. Unless you're engaging in international travel, the travel advisory is not applicable. The CDC and New York State both do strongly encourage non-out-of-state travel, but right now it's technically permitted. A reminder about New York's COVID-19 leave. Again, that was enacted last year. It provides up to 14 days of paid leave, which are calendar days. The leave rights are triggered by a mandatory or precautionary order of quarantine or isolation that's issued by the state of New York or a local health department. I know in the county where I'm located, our health department has had online since the pandemic started, employee attestations that they've inserted the Commissioner of Health signature that the employee can fill out themselves and present to the employer. I think counties across New York State at least are doing different things, but that COVID leave is still in effect. The guidance was issued on that COVID leave on January 20th. And one of the questions that a lot of clients were asking us is how many times can an employee take this COVID leave? They took it once, maybe someone in their family had COVID, or maybe they were exposed. So the guidance clarified that an employee can take it up to 3 times. And there is a limitation if they're taking it the second or third time to situations where the employee is subject to an order of isolation or quarantine specifically based on a positive COVID-19 test. And they did clarify that 3 is the maximum. They won't be eligible for any more additional leave. Moving on to some federal updates. Recently, the EEOC, if all of you employers are filling out your EEO1 data forms, those are the online data that you present to the EEOC regarding the composition of your workforce. On March 29th, just yesterday, they announced that they're going to be collecting 2 years worth for 2019 and 2020. As you may recall, 2019's collection was put off due to the pandemic, but they're going to open up their website to start collecting this data on April 26th, 2021. And employers, you'll have until July 19th, 2021 to submit your 2 years worth of data. So if this is one of those projects that's kind of fallen behind in the pandemic, I know a lot of my clients have been in scramble mode for much of the year. It's something to start thinking about again. And we do expect the Biden administration to be a bit more aggressive when it comes to the EEOC and cases they're pursuing. The EEOC also, issued some pandemic guidance that employers should be aware of. One of the questions that I think several employees that are working from home have learned to enjoy working from home. So I think some employers are struggling with having their workforces come back, and employees that may be pushing back as to whether they really need to come back to the workplace. The EEOC did clarify that a temporary shift to telework does not force the employer to accept all telework requests in the future. Pre-pandemic, we used to get a lot of questions from clients about, their employees who may have medical conditions who are requesting a reasonable accommodation to work from home, and whether the employer has to grant that as a reasonable accommodation. And it's, again, a fact-intensive analysis. During the pandemic, the doors of teleworking have been busted wide open, and employers have been allowing multitudes of employees to work from home. I will say that although, working from home during the pandemic was required, if the arrangement was working out satisfactorily, I think employers may have a hard time arguing that employees can no longer work from home if their physician is recommending it due to a medical condition. but it does remain a fact-specific analysis. And it certainly depends on the person's position. A public-facing position or customer service support, obviously working from home is not going to work. If there's equipment restrictions, you may have to provide equipment as an accommodation, or, if for some reason, in the healthcare industry, for example, where there's on-hand patient care needed, a telework arrangement is not going to work. So just be mindful as an employer, if you're getting these requests, that you can't reflexively just say, no, we don't allow that. You do have to engage in the interactive process. Turning to OSHA, another federal agency, they've been stepping up their COVID enforcement, mainly arising from employee complaints about their employers for either lack of personal protective equipment or failure to follow other guidelines with respect to what OSHA requires for keeping employees safe in the workplace. So just a little statistic, in December, they issued a news release that, OSHA had 255 inspections for violations relating to COVID, and they did issue 3.4 million in proposed penalties. So it is real. We do expect, again, a resurgence in all these agencies this year post-pandemic. Some of the violations they were writing up employers for, are not having a written respiratory protection program. If you have employees that wear respirators, are you doing the medical evaluation and the fit test and the training? Reporting injuries, illnesses, or fatalities, the record-keeping requirements, which are the 300 logs, which I'll talk a little bit about in a second. And then just in general, the general duty clause to keep your employees safe. So these are areas where they are writing up employers. Under the record-keeping requirements, employers have always been required to record illnesses that are, quote, work-related. So during the pandemic, of course, there's been questions about if someone contracts COVID and they're working, is it a work-related illness or not? So the OSHA did issue guidance on that on January 29th, clarifying, what instances employers need to record these absences on the OSHA 300 logs. I have listed the link on the PowerPoint for you to look at. In general, it's more serious injuries. If it's work-related, if they caught coronavirus in the workplace, which I think is, something employers have to carefully consider before they broadly make that declaration, because that may be subject to workers' compensation as well. But certainly you want to examine other possible areas of exposure for that particular employee before automatically deeming it a work-related illness. On January 29th, OSHA also clarified what employers need to be doing from a safety standpoint to protect their employees from the coronavirus, and it's implemented prevention programs and mitigation measures. Again, I bring this to your attention, and I've attached the link for your information. So just a few other friendly reminders of things that kicked in on the first of the year, which you're probably already aware of. New York paid sick leave statute. So that was enacted last April in the budget in the midst of the pandemic, but it didn't take effect technically, or so that employees could use paid sick leave until January 1st. September 30th was the technical effective date where employees could start accruing sick leave. And again, this is a employer-provided benefit. It's not through insurance. It's basically additional time off that employers are required to provide. In December, after it took effect, they issued proposed regulations. There's been comments collected on those. In January, employees can start using this leave. The comment period expired in February, and we are awaiting final regulations. There were definitely some gaps in the regulations that clients have questions about, relating to documentation, relating to, employers can front load the time or have employees accrue the time. And there's been questions regarding the carryover provisions of this statute as well. So hopefully those will all be addressed in the final regulations, but we'll wait to see that. As a reminder, the benefit itself, depending on the size of the employer, you must provide 40 or 56 hours of New York paid sick leave. It covers all employees. It covers mental or physical illness, injury, domestic violence situations of an employee and employee's family. You must accept oral and written requests. There's no notice requirement in the statute. It can be last minute, shift call-in, it can be mid-shift. You can ask for documentation after 3 days of absence. And, some of the questions we're getting is how does this interplay with the Family and Medical Leave Act, for example, where an employee may be out for intermittent leave if they have a chronic condition such as a migraine, headache, so they miss a day here and there. The paid sick leave would probably run concurrent with FMLA, and you can still ask for FMLA documentation in accordance with what FMLA requires. These are definitely thorny issues our clients are struggling with, and we're available to help if you have any questions. The unused paid sick leave carries over, but you can limit the use within the year to the maximum amount. So, for example, if an employee had 50 hours left in their bank out of the 56, you must carry over the 50 hours, but it doesn't mean they now get 106 hours to use the following year. You can still limit the usage to 56 hours a year. This statute also contains anti-retaliation provisions, like the rest of the employment laws. If your employee is lying about the reason for the absence and they're not really sick and they're posting on Facebook that they're on vacation or something, you can discipline them for misrepresenting the need for the absence. And do you have a policy covering this? You should at this point, hopefully. Hopefully something is in your employee handbook. If not, we recommend that you put that in there. So other increases in New York, minimum wage went up again. You can read the different areas of the state. In upstate New York, it's up to $12.50 now. In addition, the exemption and executive and administrative exemption in New York, remember, it's much higher than the federal exemption rate. Some clients, I think, aren't aware that New York actually has its own salary basis test for whether an employee is exempt or not. If you're relying solely on the federal thresholds and you're operating in New York, that can be problematic because New York's is higher. And, as illustrated on the slide, it went up to $48,750 as of December 31st. New York paid family leave benefits changed again as of the 1st. This is an insurance-provided benefit, unless you're self-insured. But, the average weekly wage and the percentage went up. So the maximum weekly benefit for 2021 is $971.61. Just FYI, hopefully you're working with your carriers on implementing that policy. That's another policy we recommend that you include in your handbook along with the other leave policies under the statute. Just on WARN, we had a number of clients that had layoffs during the pandemic. The WARN Act, New York State has a statute on it, a mini WARN it's called, and the federal statute that if you are laying off a certain amount of employees, you have to give certain notices to government agencies. On November 11th of last year, New York amended the WARN Act to include additional local governmental agencies. So again, it's very technical. If you find yourself wondering if you have to implement WARN, hopefully, I think many of our clients are in the position where they have done all the layoffs that they're hopefully going to do. But if you find yourself laying off, your workforce, these are considerations. There are penalties if you fail to notify the governmental agencies, if you're required to, and they can be somewhat stiff. So just something we wanted to highlight. And then additional updates, not religious discrimination. On January 16th, the EEOC issued an updated compliance manual on religious discrimination. This hadn't been updated in some time, so it talks about accommodations regarding scheduling changes, voluntary substitutes and shift swaps, change in job tasks and lateral transfers, modifying workplace practices, policies, and procedures, and permitting prayer and other forms of religious expression in the workplace. I do have these cases come up from time to time. Sometimes it's in 24-hour operational settings where For example, over-the-road truck drivers, they're required to work different days a week. If you have an employee asking for certain days off or shift accommodations due to his or her religion, definitely, you may be required to accommodate that employee, and it's similar to the ADA reasonable accommodation analysis. So since this updated guidance has been issued, we do expect the EEOC to start looking at these cases a bit more this year. And then finally, what can we expect a little bit legislation on the horizon? There was a Federal Family Act introduced by Congress in February 2021. It's not passed yet, but, or signed, I should say. It would provide a national paid leave program. My review of it does somewhat mirror the FMLA, except the leave would be paid, and presumably employers would be required to pay the leave. Who knows if this will pass or not, but it's definitely out there. There's another act that's not on the slide, the PRO Act, which is passed the House, which would give unions greater rights in the organization process, and it would allow union organizations much more effectively against employers. That we'll see if that ends up passing as well. And finally, on New York, the governor recently announced that there has been a deal struck between him and the legislature on legalized marijuana. So we do expect to see more on that as time goes on in the next, few weeks. But there are other states that have already legalized marijuana. So we do expect New York to follow probably some pattern of what these other states have done. But it is going to take some ramp up time to certainly, write the regulations on the licensing requirements and the approved vendors and things like that. But from an employment standpoint, I bring this up because it does cause issues with drug testing. Right now, marijuana is a Schedule I substance under federal law. So from DOT regulation standpoint, even if it's legal in your state to use marijuana, if it shows up in a drug test, it's a reason to disqualify someone, under DOT standards. In New York, it's different. There was some cases on this a couple of years ago when it appeared it was going to be passed at that time, including a taxi driver in New York City who was on medical marijuana, and they pulled his license, and the courts, the administrative agency that examined that situation held that the employer may need to make a reasonable accommodation and allow him to continue his medicinal use of marijuana, even though he's a taxi driver. So these are the types of issues we're going to see. If someone has a drug test as a part of their pre-screening process, if marijuana is legalized and it shows up on the test, our employer is going to be able to disqualify people from employment. And then, finally, New York has Labor Law 201D, which protects employees from engaging in activities off duty that are legal. So, for example, if you're a binge drinker on the weekends, but it doesn't impact your work, you can't fire an employee, who posts on Facebook about all of their binge drinking on the weekend. So it'll be interesting to see how that plays into things, if employees are legitimately using marijuana once it's legal, as long as it's not impacting their work. So those were some of the highlights. I'll see if we have any questions. And we have a couple. Let's see here. Okay, so one question was if there's CPE being offered for today's session, and I don't believe so. So a second question is there a HIPAA concern with asking to see the vaccination card? So as an employer, my position is HR can certainly see that. It doesn't need to be transmitted through 5 levels of management to get to HR. So like any medical record that your employee has, such as a workers' compensation document or a return to work note or any note from a doctor, you want to store those items separately from an employee's personnel file. But management can ask for this, and as long as you're adequately protecting the confidentiality of that information, I don't see an issue with that. With the updated travel guidelines, can employers restrict those employees who have not been vaccinated from coming into the office until after a 14-day quarantine? My answer to that would be, I would say no, given New York's current guidance. If for some reason, an employee contracts COVID after going on vacation, there is still under New York law, you do not have to provide the paid COVID leave if it was due to voluntary travel. And I haven't seen any interpretation on that yet from the health department on how that intersects with the release of these travel guidelines or the lightening of them. But I think, unless you have a legitimate business reason, I think that may be difficult to restrict employees from coming to work after they've traveled on vacation, now that the guidelines have been lifted, unless you're willing to pay them to stay home. Does the vaccination leave requirement apply to all employers, or is there a threshold number of employees? Unfortunately, it does apply to pretty much all employers. There is not a threshold number of employees. Let's see. Is there a point that employers can require that employers start coming back? Yes, especially, if as long as you have your safety plans in place, you're in compliance with New York State and the CDC and OSHA require for your workplace, you can require employees to come back to the office. Again, if an employee presents with a medical note that for some reason they're unable to work in the workplace, then you need to consider that under a reasonable accommodation analysis. If for some reason, your employees are laid off and now business is picking up and you're asking them to come back, and you have employees that say, I really don't want to come back just yet. I'm making more on unemployment, which is something our clients have faced. If there's work available, you can turn them into the unemployment office and say that they were offered work and it's available and they've refused. So you certainly can require employees to come into the workplace. Again, you have to be uniform in your policies, not arbitrary. Keep in mind protected classifications of employees, age, race, disability, things like that. But certainly that's something you can do. Okay, and I'll quickly cover one more question. Let's see. For those questions we don't get to, I see we do have a lot of participants today, which is fantastic. If we don't get to the questions today, I will follow up with people individually with their questions. Let's see. Can universities mandate students get COVID vaccine in order for them to live on campus? So that's an emerging issue. I don't know if a court's interpreted that yet, and I don't know that the EEOC has issued any guidance on that yet, but certainly we're seeing, I know at least one university has mandated vaccines before students will be allowed on campus. It'll be interesting to see how this plays out. In general, universities currently mandate vaccines for students before they enter campus. And I'm not sure that the courts are going to treat this vaccine any differently. For example, I think students have to have the meningitis shots before they enter campus. So I don't know how the courts are going to rule. I know that people are arguing that the vaccine was rolled out quickly, but there is some history of rolling out vaccines for different things. So I'm not sure if the courts are going to treat that differently. And with that, because my time's running short, I'm going to turn it over to Nancy and Steve.
Thanks so much, Kristen. Good morning, everyone. My name's Steve Turner. I'm a partner here in Bonadio's Buffalo office in our commercial audit department. A little bit about Bonadio here. Formed in 1978. We're a firm of approximately 850 employees, a top 50 firm in the country, and we have offices across New York State, Vermont, and Texas. A brief disclaimer here, similar to Kristen's as well. This is really intended for general educational, informational purposes. It doesn't represent specific advice on any of these topics. So what I'm going to talk about briefly this morning is a constant hot topic over this past year, which is the Paycheck Protection Program and the corresponding employer retention credits. There's my Bonadio baby picture on there we were laughing about yesterday. So a brief refresher on the Paycheck Protection Program, and I'm sure that everyone on the call has at least some level of familiarity with this program. There's 2 rounds of loan draws that have been opened. The first round of loans the first round is closed effectively. All of the loans that were issued within 2020 have ended their covered period, which was defined as between 8 and 24 weeks. So all of the loans that were made earlier in 2020 are within their period to file for forgiveness. So something that I'll bring up in a couple of slides from now, we'll be speaking to some challenges and opportunities around applying for forgiveness. So everyone should really consider and be strategic about how they're doing it. Don't just rush through it, because there's some opportunities for every company to get more money. So the second draw window is currently open. Any business who received the first loan may be eligible for a second draw loan as well. And with this second draw window, there were additional parameters that were set into place. I'm summarizing these. The rules get very complex depending on the situation, but in short, you need to have 300 or fewer employees, and you need to have demonstrated a 25% or more drop in quarterly revenue in one quarter of 2020 versus the same quarter of 2019. So for example, if in the second quarter of 2020, as compared to the second quarter of 2019, you had a 40% drop in quarterly revenue, and you have under 300 employees, you may be eligible for a second draw loan. With this program, and also with the employer retention credit program, you need to consider affiliation rules. And to make things more complicated, the rules are different for each of these 2 programs. So the PPP operates under the Small Business Administration's affiliation rules, which are really based on control definitions. But if you have, either if you work for, you own a business that has multiple ownership interests, you may need to affiliate these for the purposes of determining not only employee headcount, but also drop in quarterly revenue. And as with so many presentations that we've given over this past year, this has aged poorly. Even from the other day, the application window has been extended to May 31st, an additional 2 months. There's plenty of money left in the program as it stands today, and every business should really consider if they're eligible, and if so, they should work with their lender to apply for a second draw loan if they so decide. And an additional reminder here, both rounds of the PPP loans require a minimum 60% spend on payroll costs versus up to a 40% spend on non-payroll costs. And where this kind of comes into play here is the interplay between PPP and the employer retention credit, which I'll speak to. There may be opportunities to search for and increase your non-payroll costs that you include on your application in order to maximize your employer retention credits. Here's a chart. As Krista mentioned earlier, the slides are available. The PowerPoint slides are available within the presentation window. So feel free to dive into this a little more closely as a reference for you. I understand that it's probably small on the screen, and I cut this down as much as I could. It's indicative of there being a lot of rules, a lot of information that govern this program. But in short, a couple of the key differences between 2020 and the 2021 version of this credit. The 2020 version of the credit, you can qualify in one of 2 ways, either a significant decline in gross receipts, which for the purpose of the ERC in 2020 is measured as a decline of more than 50% in a quarter of 2020 versus the same quarter of 2019. Or you can qualify based on a full or partial shutdown of your business due to government of the business. And this is where this credit not only becomes, it creates more opportunity for companies looking retroactively to 2020, but it also makes it more complex too. Were you shut down by an executive order, or were your customers restricted? There's a difference with these things. For 2021, it's been lessened to a decline of more than 20%. So although that decline has happened, recovery is balancing against that. So you need to kind of examine your case-by-case basis, think maybe restaurants or hospitality that are still restricted by government order at this time versus other industries that may be continuing to be impacted on a gross receipts test basis. As I mentioned previously, this program has its own aggregation rules that are under Internal Revenue Code rules, a little different than the SBA rules as far as aggregation, but something that needs to be considered and documented in order to determine eligibility. And another key piece here, if you look on the line that says small employer, large employer threshold, the credit is more valuable for employers indicated to be small employers. For 2020, this means that you had 2019 full-time employees of less than 100. For 2021, you look back to 2019 still, and the threshold's been increased to under 500. The difference with this being that if you are a small employer, you can be eligible for the credit for wages paid to all employees for time that they're both working and not working. So you can see how that can add up pretty quickly. As far as the dollar amount of the credit, the maximum credit that can be claimed per employee for 2020 is is $5,000, and that's based on 50% of up to $10,000 in eligible wages, which include employer-paid health care in that number. So for each employee during 2020, you can claim up to $5,000. For 2021, this threshold actually, it's 70% now, and that's 70% of up to the first $10,000 per quarter. So in a case where an employer with approximately 100 full-time employees was eligible for the credit for 2020 and for every quarter of 2021, you can see how this could add up. You could be talking about, $500,000 plus another $700,000 times 4. It's a substantial credit. How to claim the credit for 2020 needs to be claimed on a 941X, which is a quarterly payroll tax filing amended return. For 2021, you have a couple different options. You can stop paying and you can reconcile at the end of a quarter, or you can file a 941X. I wanted to present just kind of a brief case study so people could start thinking about, if you haven't, the opportunities for optimization that exist here. Just a brief example case, company AAA has 75 full-time employees. It's eligible for Q2, Q3, and Q4 2020 based on a significant decline in gross receipts, meaning we can look at this window to calculate eligible wages. And for the purposes of this calculation, I said that all the employees make $10,000 gross per quarter. They also received a PPP round 1 loan for $625,000. I kind of worked this example to be 2.5 times an average month of payroll for this company, with the covered period beginning and ending within the ERC eligible period. So in this specific example, let's say that the company received their loan on maybe May 1st of 2020, ran it for 24 weeks, and they still had some time after the period of the covered period as well to utilize for ERC eligible wages. Also, company AAA in this case, let's say they have enough qualifying non-payroll costs during their covered period to make up that 40% of their PPP-1 loan. And another point to make about this is that the non-payroll cost definition has been expanded, both retroactively for PPP Round 1 and prospectively for PPP Round 2. So there are opportunities to pick up qualifying spend that you would be making in the normal course of business as it stands already. So the best way that I could illustrate this example of optimization is just by a simple visual here. The PPP1 covered period is indicated by orange. You can see where the cutoffs between Q2, 3 months in Q2, 3 months in Q3, 3 months in Q4, and the approximate PPP1 covered period within there indicated as only 5 months in this case, but in many cases, most companies were able to spend down their PPP money inside, or less than rather, the full 24-week period. And those that were able to do so would be able to pick up wages within the blue indicated pieces of this chart to calculate an employee retention credit. So there are many, many opportunities to optimize this, and I'd recommend that you work with your advisor. This is something that Bonadio has been actively focusing on for this entire year now at this point, CARES Act, PPP, ERC, and we have plenty of cases where we've been able to identify substantial amounts of credit that would have been missed out on. Just yesterday, I finished a calculation for a client that had they not held off on applying for their PPP round one, they would have missed out on $225,000 in eligible 2020 ERC. There's opportunities within here to pick up any amounts over $10,000 per employee, allocate that to the PPP. So another piece on this as well, that my last piece is that with PPP2 loans either being still made or having been recently received, it's just as important in 2021 to kind of consider this optimization as you project and spend down your loan money and consider eligibility for ERC. And there are still opportunities to go back retroactively and optimize and file for this credit, even if you've already applied for and received forgiveness on your PPP round one loan. So brief overview there. It's a lot of information, so feel free to follow up with any questions that you might have. I'm going to pass it over to Nancy. Thank you.
Thanks, Steve. I'm going to go through my slides hopefully quickly enough that, so Steve, I see there's a couple of questions for you if you want to take a look, and hopefully at the end we can get back to those. But again, anything that we can't get to, we will follow up on. So hi, I'm Nancy Cox. I'm a partner at Bonadio, specializing in employee benefit plans. And I co-lead our employee benefit plan audit practice, which we have a large one. We do over 500 employee benefit plan audits as a practice. So I wanted to just go over some considerations for plan sponsors as it relates to potential impacts of the pandemic on ERISA plans. So the first thing that I'm talking about is cybersecurity, which is obviously not a new concept, but it is increasingly important. I mean, especially as it relates to ERISA plans, if you think about all of the money that's in them, and then the fact that, there's definitely less of a paper trail. Things are done electronically, and there's more and more people working remotely. They may be accessing data from their mobile phones or other places, and so it does become increasingly important. And so what's at risk? Basically everything, right? And the participant data, social security numbers, all of this personal information, and then the plan assets themselves. So during 2020, there could have been increased distributions and loans, perhaps more money coming out of the plan. So, there's a lot at risk, right? And so what are the fiduciary responsibilities? ERISA regulations are silent specifically as it relates to cybersecurity because they were written, prior to it becoming an issue. But fiduciaries do have a responsibility to act in the best interest of the participants and to take reasonable actions to protect plan assets, including personal information. So it is a fiduciary responsibility. So what's a fiduciary to do? The first thing is really to start discussions about it. So go into your plan committee meetings with other plan fiduciaries and figure out what you're dealing with, and figure out, first of all, is there already a plan in place perhaps at the organization that relates to the plan itself? Where is information stored? So probably, obviously, it's going to be at your organization, but it's likely at different service providers as well. Payroll providers, a third-party administrator, custodian. So figure out where is data stored. And then once you have that figured out, figure out what's going on there. So at your organization in general, you probably have some sort of cybersecurity plan for the organization. Does it speak to the ERISA plan within there? If it does, great. If it doesn't, start having conversations about how to get it incorporated. What are some mitigating factors that you could put in to mitigate the risk? And then what's going to happen if there is a breach? How will you react? For service providers are audited also. Their internal controls are audited by independent third-party accountants, and they have a report called a SOC 1 report or an SSAE 16 report, but it will basically detail out, number one, if the internal controls are operating effectively, and then it will show you what the auditors tested and if there were any exceptions. The one thing is, if you ask for this report, which you should as a plan fiduciary, to ensure that there are sound controls at your service providers protecting your plan assets and your participant personal information. So ask for these SOC 1 reports. When you get them, you'll likely get one that relates to the retirement plan operations. Sometimes the IT general controls are carved out of that report. So look for terminology like, carve outs or subservice organizations. If the IT general controls are carved out, ask for the report that addresses them, because you want to make sure that they have internal controls in place to be protecting the plan assets. At your own organization, think about the mitigating controls that you have in place over money coming out of the plan. Are you reviewing monthly reporting to show what kind of distributions and loans are coming out of the plan? Because again, most likely you're no longer approving them before they come out. So you're really just kind of looking at what's already come out, but make sure that it looks right. Did that person, terminate or retire? Is this money coming out appropriate? And of course, monitor user access. At your organization, make sure that you're constantly looking at that. So in short, I would just make sure that there's at least you're working toward having a plan in place to mitigate your risk, and then address a breach should one occur. And of course, you can't always totally eliminate this risk, but it's something that as a fiduciary, you need to demonstrate that you've thought about. So moving on, in 2020, there could have obviously been some staffing and resources differences. There could have been turnover, lack of resources, a shift in priorities, which of course that happened at many organizations. I mean, there was a lot of things going on during 2020, and it could have led to a lack of segregation of duties as it relates to plan operations. So my suggestion is just to take a little time and review areas, where there could have potentially been errors. And I'm just going to kind of list out, through all of our audits, we tend to see errors happening in the same areas. So I just listed out a few for you to consider. The first one being basically any plan provision, but it's the execution of the plan provisions as it relates to the plan document. The biggest one being the definition of plan compensation. So we do often see errors as it relates to misinterpretation of the definition of plan compensation. So sometimes if bonuses or fringe benefits are included or excluded, those things get missed. And so every year when we do an audit, and this is what I suggest for plan sponsors to be doing on their own, is get your plan document, not your summary plan description, but your legal plan document, and review your plan provisions and just take a look at them compared to how you're actually operating the plan and make sure it's the same. So whether it be the definition of plan compensation, eligibility is another place where we often see errors. A lot of times I'll talk to someone in HR and they say, yeah, part-time employees are not included in the plan. But if you actually look at the definition within the plan document of eligibility, they're not specifically excluded. And so you just want to go back and familiarize yourself with the terms of your plan and make sure that you're actually, carrying out the plan provisions in the manner that they're stated in the plan document. A big one that we often find errors is timely deposits. So basically, the DOL is hot on this as well when they come do audits. The general rule is that a plan sponsor has to deposit 401k deferrals at the earliest date that they can segregate them from plan assets, but in no event later than the 15th business day after that month. And so what they've determined is if the DOL is doing an audit, they'll come in and see the day that, let's say you've shown that you can deposit deferrals the day after you've withheld them, then that's the day that they say, okay, you can do it that day, you should do it that day every single time. And that's what they'll hold you to. So the first thing that you want to do is just go and see if you're consistently applying, the day that you actually deposit the deferrals. If you're not, then figure out a way to consistently do it. And if there are outliers, which of course there are things that happen, right? If there's a holiday or somebody's, out of work or whatever it may be, just document it. Document it so if you do get audited, you can say, yes, we missed this day because, so-and-so was out with COVID or whatever it may be. If you do find that you have an error, so if you go over the 15 business days, let's say, then there are many plan ways to correct. I've listed them out here. They're extremely easily Googled because the DOL and the IRS have provided these to make them easy because they want you to self-correct. It's cheaper, it's easier, it's less expensive if you just self-correct rather than having it found under audit. And all the general rule is basically that you just want to make a participant whole as if the error had never occurred. So again, I've listed out some of the different correction methods. The IRS method is for those operational errors, so like using the incorrect definition of plan compensation. And if you go to Google this IRS employee plans compliance resolution system, it will also come up with this IRS 401k plan fix-it guide, and it very easily spells out, okay, here's the issue, here was the error, and here's how to fix it. Again, they do make it easy for you to do. The DOL Voluntary Fiduciary Correction Program is for prohibited transactions. So that's like if you're holding on to participant contributions too long. So like the timely deposit issue. There is a filing and a very minimal penalty associated with using that. But again, it's very user friendly. And then the DOL Delinquent Filer Voluntary Compliance Program, that's just bringing you into compliance with all of your required filings. So like your Form 5500. Again, these are all really user-friendly and easy to use. I just wanted to mention partial plan terminations just because of the year, that we've had. And so the determination of whether a partial plan termination has occurred is based on facts and circumstances, whatever that means. But as a general rule, the IRS says that more than a 20% reduction in the number of covered participants during a plan year is considered a partial plan termination. So again, I throw it out because it's always something that you have to consider. It just might actually be something that has occurred this year. And if you've determined that you have had a partial plan termination, all affected participants are then immediately 100% vested. The good thing is this Consolidated Appropriations Act extended the termination period to March 31st, 2021. For any plan year that includes this covered period, which I have shown here. So basically no partial plan termination has occurred if your active participant count as of March 31st, 2021 is at least 80% of the active participant count on March 13th of 2020. So that's a good thing. So as of tomorrow, if you think you may be in this situation, you have as of tomorrow to figure it out. I just listed out a couple of other random considerations. So if you did adopt any of the optional provisions related to the CARES Act, just a reminder that they should be formally amended, and in general you have until 2022. Fraud goes hand in hand kind of with your cybersecurity considerations, and really you want to take a look at money coming out of the plan, as I mentioned, and make sure you have mitigating controls surrounding looking at those distributions and loans and money coming out of the plan. I like to just talk about managing liquidity because I do often find that plans will have a forfeiture balance that they haven't used. And you can use it, look at your plan document to see what you can use it for, but generally you can use it to pay plan expenses or to offset your employer contributions. So take a look at that. Make sure that every couple of years, I would say 2 or 3 years, you're looking at, you're doing benchmarking for your vendor fees, and using someone independent to take a look at those. But that really is, as I talk about next, fiduciary best practices, that's one of them. Just making sure that you're really looking at those fees. We've talked a lot about some fiduciary best practices, but I do like to just say it's important that you have a committee of the right people, and that you meet regularly. I would suggest quarterly, and that you document the things that you're talking about in your meetings. All of these things that we've been talking about for the last 15 minutes, document that you're doing them, that you're working in the best interest of your plan participants and trying to protect plan assets. The last thing I'll quickly mention is if you do have a large plan and you're audited, so if you have over 100 participants and you do have to have a plan audit, our standards are changing. So in 2021, there are big changes coming to employee benefit plan audits. And so if you do have an audit, you should just be speaking with your plan auditor just to see if there's anything you need to prepare for 2021. That's all I have. So I'm gonna let maybe Steve or Kristen, if you want to, for like 2 minutes, go back to some of the questions that you guys had.
Sure. I'll touch on two quick questions that came in. The first is a question around effectively double dipping. Can you use the same wages for PPP forgiveness as you're using to calculate ERC eligibility? And great point. You cannot. There is no double dip allowed. So that's really what where this optimization and kind of analysis of the two different windows of eligibility and your bucket of eligible wages for each come into play. Another question that came in said, are the ERC qualified wages deductible for tax purposes? And another great point here. Well, the PPP loan forgiveness is not federally taxable, and in New York State is not taxable. That's not the case for every state, but as far as federally in New York State, PPP forgiveness not taxable. The employer retention credit itself, so if you think about it as $5,000, up to $5,000 per person, would be netted against your deductible wages. So in effect, making it net taxable, the credit itself, not the wages, not the bigger number that you're calculating on. One other question that came in that I'll just briefly touch on is a question around accounting methodology for determining eligibility for, I don't know if this is asking about PPP or ERC, but it's a consideration, and there may be an opportunity for you to consider reporting on a different basis than you normally do, meaning if you're normally in accrual accounting, if you normally use the accrual accounting method, there may be an opportunity to go cash basis to determine your eligibility and therefore make you eligible. I think that's it that I had there.
I can answer a couple of just quick questions here before we wrap up. One question was whether for the COVID vaccination leave, can you force employees to use their paid sick leave? And the answer is no. It's a completely separate benefit, so it's in addition to the paid sick leave. Another question was whether the travel guidance for April 1st, which does not require quarantining for the non-domestic travelers, whether they're required to be vaccinated. And the answer to that is also no. It applies to anyone that travels domestically in the United States returning to New York. There is no quarantine requirement after April 4th. Someone also asked, when do the travel regulations end? They are still in effect. Even after April 1st, there are requirements for international travel in New York State and quarantine requirements. Let's see, and I think I've covered several of them, and we're just about out of time. So thank you, Nancy and Steve. It was a pleasure presenting with you. And thanks to everyone who joined us.
Thank you.
Thank you, everyone.